What are the grounds for divorce in the state of Georgia? Hi, I'm Samuel Thomas, a divorce attorney here in Athens, Georgia. Today's video discusses the different grounds a party may seek a divorce in the state of Georgia. The law here provides for 13 legal grounds for divorce. Persons involved in a divorce need to only identify one of the legal grounds, but may assert multiple grounds. Each of the legal grounds for divorce requires certain conditions to exist in order to formally assert any particular reason for getting a divorce in Georgia. When we're talking about fault versus no fault divorce in Georgia, getting a divorce in Georgia does not require the determining fault, meaning Georgia is not a fault-based state. However, of the 13 grounds for Georgia divorces, there are grounds that may be cited which do create a condition of fault. Regarding fault grounds in Georgia, fault grounds are described as, yes, one spouse can allege that the other spouse caused the breakdown of the marriage by some behavior. Some fault grounds for divorce include adultery, desertion of a party, mental incapacity at the time of marriage, marriage between two closely related people, impotency at the time of marriage, force or fraud in obtaining the marriage license, conviction and imprisonment for certain crimes, mental or physical cruel treatment, habitual intoxication or drug intoxication or addictions, and mental illness. Do the grounds asserted affect the outcome of a divorce? Generally speaking, the specific reasons for getting a divorce can play a role in how your divorce is settled. What typically plays the most significant role, especially when filing a contested divorce in Georgia, are the details surrounding the ground for divorce. Many low conflict, uncontested divorces, particularly divorces not involving children, cite irretrievably broken and avoid excessive public disclosure of facts. Whether uncontested or contested, if the facts in your married life involve criminality, egregious or salacious behaviors, a judge may apply a bias in the final terms of the divorce order. Certain grounds for divorce can provide a strategic advantage. Grounds for divorce that reflect unacceptable behavior can create a condition of at fault, which can impact decisions on awarding alimony or spousal support. The 13 grounds asserted for Georgia divorce in the state are found in OCGA 1953, is where you can find the exact language of the laws regarding the divorce grounds in Georgia, including adultery, which is referring to the illicit, non-mutually agreed upon sexual relations outside of the marriage, criminal conviction for a crime of moral turpitude, which requires 2 or more years incarceration, cruel treatment relative to any verifiable proof or demonstration of mental abuse or physical abuse, force, duress, or deception, effectively meaning manipulating your spouse to get married when they otherwise would not be willing to do so. He also defines habitual addiction or intoxication as involving alcohol without action to address their problems. Habitual addiction or intoxication involving pharmaceuticals and or illegal substances without action to address their problems. Mental incapacity at the time of the marriage. This generally claims that you or your spouse were incoherent or mentally incapable of clear thinking at the time of the marriage ceremony. This can include people with known mental disorders, being severely intoxicated or under the influence of drugs or similar conditions at the time of the marriage. Impotency at the time of marriage and without your knowledge or of the condition or of the impotency. The intermarriage between persons with close bloodlines, wherein the relationships between the husband and wife would generally qualify as incest in our state of Georgia. An incurable mental illness, which requires a history of being institutionalized and formal testimony from at least 2 psychiatric professionals and or doctors. The other one, irretrievably broken marriage, also known as irreconcilable differences, requires agreement by both divorcing parties. This provides a certain level of privacy regarding the details for the divorce. Another one would be pregnancy of the wife by someone else other than the husband at the time of the marriage. We also have the ground of desertion or abandonment, which applies if either of the parties leaves the marriage with no intent to return for a period of 1 year or longer. If you would like to discuss these grounds of divorce, given your specific facts to your case, feel free to call our office at 706-546-0999, or feel free to reach out to us via our website at www.samuelthomaslaw.com. Thank you.